Resolutions. And I think we got to just starting about talking about arbitration, if I'm not mistaken, as we looked at some of those major settlements. So arbitration is well regarded. It's favored by federal statute. Okay, they like it as a means of settling disputes. Keeps it out of the courts, right? So it makes it a little less busy for our court system, which is oftentimes overwhelmed. Arbitration can be mandatory. There are states. I'm not aware that Montana has any mandatory arbitration requirements. To my knowledge, Montana does not, but other states do, and they may set amounts. You know, if Aaron and I were going to be in a dispute and it was under $10,000, we might have to pursue arbitration as opposed to taking it to small claims court. Okay, there are some states that have some rules like that. To my knowledge, Montana does not have any mandatory arbitration rules. Voluntary, however, is pretty common. You know, and I showed you the arbitration with the athlete, Davis, I think his name was, baseball player, and he arbitrated his contract with whatever team it was that he was getting his contract with. And that's fairly common, and not just in athletic contracts, but in other contracts as well. Okay. When we talk about arbitration versus mediation, when you submit to arbitration, the arbitrator's decision is final and it is binding. It's as binding really as a judge's decision. Okay? And it's because really when you enter arbitration, you're entering in a contract where both parties agree that we're going to let somebody decide this ahead of time. Okay? And so when that person decides it, then by golly, it is binding. Okay? Generally, it's quicker than courts. Trials, if you follow any of these trials and some of these civil cases and whatnot, some of them take years. Okay? I mean, months are certainly not unusual, but some of them take years to get settled, because they're complicated and on and on and on. Ease the court dockets, because this takes place outside of the courtroom, right? Expert assistance, and that was, when I talked about that guy signing his contract, arbitrating his contract with the team, right? You don't get a judge or somebody like that that's doing the arbitration. You get somebody that's an expert on baseball, okay? Somebody that follows baseball, that knows the statistics, that knows, a lot about the game, is also is schooled and does have some legal knowledge. There's absolutely no question about that. And then they become the arbitrator. So what's it mean when we submit to arbitration? Okay, and there's a couple different ways you can do that. Often it'll be right in the contract. Okay, often it'll be right in the contract. So you sign a contract with another party, and it says right in there that if we have any disputes about this, we agree to arbitrate that dispute. That may be something as simple as your contract for your television service or your internet service. Okay, a lot of those things that you probably don't read. I don't. Okay, the end user legal agreement or whatever, the EULA or whatever the heck it is, right? And you see those a lot of times when you're scrolling down. Do you accept that? Does anybody ever read those? No. Okay. Got a lot of good legal language in there. It will really confuse you. But some of those probably carry arbitration agreements. Okay. When you click the I accept, you've probably agreed then that if you have some kind of a dispute later on, you're gonna settle that through arbitration. And there's nothing wrong with that. Okay. The parties can agree to up front, in that case, to arbitration. But arbitration can come later as well. Let's say the original contract didn't have an arbitration clause, but you start having a dispute, and you say, we're just not going to settle this ourselves. Why don't we have an arbitrator do it? And so you can submit to the arbitration at a later time then too, right? So really any time in that process, from the time a contract is engaged to a time when there's this ultimate settlement, right? You can agree to enter into an arbitration. Generally, you agree to some specific matters, and this is especially true. I would guess that the early ones, if it's part of the contract, are pretty general. It probably says any dispute that arises, we're going to settle through arbitration. But if it's later, okay, and you're going to arbitrate it, you probably agree to some real specific items then that you're going to have arbitrated. Sort of like a court, the arbitrator's the judge and the jury here, though, right? Because there are questions of fact that would come up. There can be questions of law that would come up in an arbitration. So you've got both fact and law that the arbitrator is going to make decisions about. The legal matters aren't going to be as intense as it would be in a court of law, obviously. Okay, you're going to bypass some of those. And there's a trend towards arbitration. Okay, there's some worrisome things about that, and I think I'll talk about those here in a little bit, about some of the worrisome things. Sure, act of referring, kind of hit those, kind of talked about that already. Voluntary, mandatory as occurs when there's a court. Courts could require it too, right? If two contracting parties, and maybe they're going to sue each other, the court might say, nah, you guys just go arbitrate this. Go get an arbitrator. They might say that because an arbitrator would have more expertise in the field, right? Whereas the court lacks that. A judge may not know anything about baseball, okay, and may lack that expertise, and so may decide that this should go someplace else. The decision made by the arbitrator is called an award. That's just kind of the final decision. Doesn't necessarily mean that it's monetary, right? It could be specific performance. You will finish what you started, that type of a thing. I kind of got ahead of myself. Obviously, now we're talking about the submission and what can happen, right? Has to be within a stated period of time. Okay, so if you have that dispute, you might be a specific period of time. Again, I kind of got ahead of myself. Expertise, right? Using an expert in that field. Arbitration can sometimes, it can be one person. I see that with the athletic contracts. It's generally just one arbitrator. So they agree to that. There's probably a pool of people out there. Maybe they draw a name out of the hat. I don't know how they pick them. I'm not sure. What usually happens, there's oftentimes a panel of 3 arbitrators, and what they usually do there is each side will pick one arbitrator from a pool. Again, there's a pool that are considered experts in the field, that are considered experts as arbitrators. You could become a professional arbitrator, by the way. I mean, that would be a career potentially, right? There's a pool then of arbitrators that are out there, and each side will pick one, and then those 2 arbitrators will pick the 3rd arbitrator. Presumably then that 3rd person would be, hopefully, kind of more nonpartisan, I guess. But it could be 5 if that's, but generally speaking, it's kind of 1 or 3, I think, are the most common. Again, certain matters, certain topics, certain areas of expertise, we have arbitrators that do that. This used to be, I think, in the text. I don't think you guys have the Rent-A-Center one anymore. And it really had to do, again, with a contract, and there was an arbitration clause in the contract, okay? But the party, Jackson, I guess, in that case, he said, I didn't want to, I gave up my rights of our legal rights when I signed the arbitration agreement. I didn't want to do that. And it went to the court, and the court said, no, we favor arbitration. We absolutely favor arbitration. So you will arbitrate it, and you will accept the award of the arbitrator. I believe that that's correct, if I remember the case, yeah. Believed that the agreement to arbitrate was unconscionable and unenforceable under Nevada law. And, if I remember, the resolution of that case was in favor of Rent-A-Center, that no arbitration is favored. So the advantages of arbitration, not as expensive, right? But it also takes less time, and it is non-public. All of the following are advantages then. Right to appeal. It's not really in there. There are some limited rights that you can, obviously, if you went back to this case, this guy didn't, he didn't like the arbitration, and so he sued, and so in effect it was kind of an appeal, but it's not called that. Okay, so there is no right to appeal with arbitration. But typically they take less time. Non-public's a good thing, right? If you're a business, again, we talked a lot about that when we talked about litigation and whatnot. You don't necessarily want to be on the front page, that so-and-so filed a claim against you. But if you arbitrate it, it doesn't have to be public then, right? Absolutely no requirement for anything to be public there. So that's oftentimes, a part of the arbitration agreement is that, hey, we'll keep this out of there, right? So the Federal Arbitration Act, right, it encourages people to use arbitration, still does. Courts do enforce, though, when there is an award, the courts will enforce that. So it's just like you went through litigation and there was a legal rendering of a legal opinion. Federal policy certainly favors that, and the Supreme Court has typically upheld arbitration types of agreements. Some state laws have sought to reduce, I guess, the power of arbitration, and for the most part, when those have gone through the courts have come back and said, no, arbitration is still a perfectly good way to settle disputes, and we still favor that, right? Some, again, statutorily mandated. I'm not aware of this happening in Montana, okay? Arbitrators are oftentimes retired judges or practicing lawyers, so they do have, they're well-versed in law. So when we talk about facts and law, they're well-versed in law, but oftentimes, again, they'll have that legal expertise. I would bet a lot of them are in employment, because I'll talk about arbitration and employment here in a minute. But a lot of them are probably in that employment law side of things, because that's where a lot of arbitration occurs, is in employment law. Claims for, these are the mandatory ones. Again, when we're talking about mandatory arbitration, a lot of times it's claims for money of small amounts, where a state may say, we're not going to clog up our justice courts, small claims courts, whatever. You guys arbitrate it. There's people out there. Each side maybe pays them. I'm not sure, or the loser pays, whatever the case may be. Proceed like that. Mandatory arbitration doesn't necessarily provide speedy justice, right? Could be some discovery, so it becomes a little bit more like a typical courtroom type of a thing. Again, determine admissibility of evidence, et cetera, so it does become a little bit more like that. So what are some typical ones? Again, you'd probably be surprised to see, if you read some of those EULAs, I'm pretty sure that's what they are, end user legal agreement, something like that. If you read some of those, you'd probably find arbitration clauses in there. Again, it's probably just going to be a simple sentence that says, if there's any disputes in the future, we agree to arbitrate those disputes. Might be something as simple as that. Okay, and small print, even if it's not online in one of those end-user legal agreements, it could be, in small print on some other agreement that you would sign. The one, brokerage firm and employee, but it doesn't say a lot here about employer and employee, and those are becoming more common. And I'll admit that that's one that kind of gives me the irps a little bit, okay? And the reason is, you guys are sitting here in college now, this is a 200 level class, so maybe you're sophomores, whatever, a couple of years you're going to graduate. You're going to get offered a job, hopefully, okay? If it's a local place here in the state, no big deal. Most of them probably don't have any arbitration agreements. But you might get offered a job by GE. Okay, you might get offered a job by Wärtsilä. You might get offered a job by some of the companies, big companies that come and recruit. And you sit down and you accept the job, and you're there, you're signing up, you're doing all that stuff. There's probably an arbitration agreement in your employment contract. Okay, and in essence, what are you going to do? You want the job, you're not going to stand up and look the HR person there in the eye and say, I ain't signing no arbitration agreement. I'm not giving up my legal rights, because in a sense you are giving up a little bit of your legal rights, your rights to sue then if something were to go wrong in the future. Okay, so that is a little bit concerning for me, when you get to that employer-employee thing, because employers have a lot of power, at that point in your guys' career. Now, that said, I don't hear a lot of abuses about that either, because most people go to work and they work and everything's fine and there's not a lot of disputes, right? So there's not a lot of abuses that happen there either. My other concern about that a little bit is if you enter into that type of a contract, and whether it's an employer or employee, but think about consumer, big company. Okay, remember how I told you they pick arbitrators? You know, well, if you were really wanting to make money as an arbitrator, would you tend to side with big companies that might go to arbitration really often, or would you tend to side with consumers who you're never going to see again, right? You know, Aaron might once in his life be a party to an arbitration, and probably not, right? And Aaron's got a dispute with Microsoft. Okay, Microsoft probably goes to arbitration every day of the week, you know, in some fashion or another, maybe, right? And so if you're an arbitrator, you may tend to kind of side. So there may be a whole bigger pool of people, of arbitrators, that kind of side with the bigger company. That's an assumption on my part. Again, I say those things, but I also can't tell you that there's abuse of that, okay? I mean, and there's not evidence of abuse of that. So just kind of concerns that I have, I think, more than anything else. So awards, right? Decision by the arbitrator, they do have to be disclosed. That doesn't mean that they have to be published, okay? They don't have to be unsecret. They can still remain secret. And oftentimes that's a part of the final agreement or the final award, is that, you know, both parties will keep it zipped, right? And it's final. It does get disclosed to the courts. When they say disclosed, that's really what happens, is it gets disclosed to the courts. And it's not subject to judicial review on the merits of the decision. Okay, merits of the decision, more the fact. Could the law still? Yeah. I mean, an arbitrator's decision that's capricious, that's obviously, maybe there was bribery involved, something like that, right? Those types of things can obviously be reviewed, okay, by the law. So kind of already talked about that. Can have a pre-dispute or post-dispute arbitration clause. That's the submission. Judicial review is limited. Kind of talked about that. The error of the law. You know, that's the big thing. So if the arbitrator, if there's a mistake as they're going through this in terms of the law, that could potentially cause an arbitrator's award to be overturned. It just, you don't hear about this very often, so it doesn't happen that often. Most arbitration awards are upheld. Again, probably 99% of them. There's probably just a very few where something goes wrong. So mandated when it's mandatory, higher level judicial review. So that might, you know, again, if it's small claims, it might, maybe a state district court has to take a look at it and stamp their approval. And again, Montana doesn't have mandatory arbitration that I'm aware of, and so I'm not that familiar with what the procedures are there. Court tries the issues anew as if no arbitration. If there's a claim from one side or the other, that basically an appeal in this case, if it was mandatory. Again, this is just mandatory arbitration. Not something I'm that familiar with, so. Award was procured, corruption, fraud, bribery, whatever. If you can prove that the arbitrators were partial or corrupt, that could happen, right? Guilty of misconduct, again, bribery, things like that. Exceeded or imperfectly executed their powers, okay? Some of those are really tough to prove, okay? And again, it doesn't happen that often, so. Oh, yeah. Something we say every day, huh? So now let's talk about mediation, okay? Mediation is not necessarily dissimilar to arbitration, except it's not binding on either party. Okay, and here I'll throw you a little bit of a curveball and make it a little bit confusing. If the parties come to an agreement at the end of mediation and they write that agreement down and sign it, then it's binding, okay? But up until that point, there's nothing about mediation that's binding, and nor can the mediator impose a binding solution, okay? Only if the parties agree to it and sign it, okay, will it become, okay, something then that could be upheld? Does that make sense to everybody? I've been in, I think just one, if I remember back. One that was mediated. It was kind of an interesting process. I mean, I was an executor of an estate, PR of an estate, and there was one little issue that was unresolved, and the two lawyers that were involved in this called in this mediator. I was just more of a disinterested third party at that point because the lawyers were both there. They called in this mediator. The mediator came in, and we kind of had this lengthy discussion. Again, I was a little bit just kind of listening. It was kind of interesting, and they started writing down on this legal pad, yellow legal pad, you know, what the terms of it were. And when they got done, all the parties signed that yellow legal pad, and that became the official. That was actually entered into the court as part of what the official legal document was that enforced that particular mediation. It was kind of shocked me. You know, you're used to seeing the lawyers having all these long things and typed out and, you know, on and on. And no, this was just written down on a yellow pad, so it's pretty interesting. It was a relatively small matter. You know, it seems weird that we had to have a mediator come in, and I forget what they charged. I think it was $4,000 or something like that, you know, over something, yeah, that might have involved a $20,000 thing, you know, so a lot of money for that. But so becoming a mediator is not an all bad profession either. So, you know, years ago, probably about the time I started teaching up here, but the hospital and the nurses over here had a dispute. And the nurses were threatening to go on strike. When you came up to the college, 13th Street over here, the cars were parked there, and they had signs on that said, support the nurses, support the nurses. And it was kind of nasty. And the HR gal over there at the time, Colin Pekluski, I think was who it was, and I knew her pretty well. And later I asked her after they solved it, because I knew that they'd called in this mediator, and I said, you know, is that what made the difference? And she goes, oh, absolutely. Absolutely. This mediator was totally invaluable. And the guy came up from Texas, and I asked her what it cost, and I think that one was well over $20,000. And he was only here for a couple days, and they ended up resolving the dispute. So, yeah. So it's, like I say, it could be a pretty good profession if somebody wanted to get into mediating. Once again, it's kind of like those arbitrators, though. It's probably going to be attorneys, you know, retired judges, retired employment experts, you know, in a case like that, things like that. So you've seen that person?
No, I've never seen that version.
Oh, okay.
Usually only talks about when he
Yeah. So what's the advantages, right, of mediation? The parties agree, you know. Oftentimes they know that they're just, oftentimes there's a lot of anger maybe on both sides, especially when you get into employment things. And so you realize that, and you realize that, you know, there's no way we're going to settle this thing because we're just too pissed off at everybody. Maybe that's why I had the meme, you know, the one before. We're just too mad at each other. We need to settle things down a little bit, right? On the other hand, you retain control, right, of the outcome, reduce the burden on the legal system. Disadvantages of course, the mediator cannot enforce it. Again, if you come to an agreement, that agreement itself can be enforced. It becomes just a contract, right? And then selecting the mediator and the qualifications that are involved in that. You know, and that's got to be a person that's, you know, can handle that anger, you know, handle that kind of situation, and also be an expert in the field, have an understanding of what's going on in that area, you know, whether it's employment law or, in my case, it was estate, you know, the one that I was involved in, it was an estate type of a thing, so. So the mediator, right, comes in, explains what kind of procedures they're going to go through. They make statements about the dispute, both sides, okay? Exchange, parties talk to one another, okay? generally speaking, solutions are maybe brainstormed. But, what I've seen when the mediator comes in, and this was how it worked with the mediation that I was in, but I think with the hospital it was a little bit different. Instead of bringing the parties together, the mediator said, no, you guys go to neutral corners. You're a little bit too pissed off at each other. You go here and you go there, and I'll work in between you, and we'll do all this same stuff, but you guys aren't hearing each other, and so, you'll make your points and you'll make your points, and then as the mediator, I'll see if we can come to an agreement somewhere's in the middle, and take the emotion out of it. And that's the caucus there, right? Oops. So the difference get resolved, right? Gets written down, and then it gets signed by the parties. Mediations emerge. Yeah, primary. Mediation can be mandatory as well. And oftentimes it has been mandated in big cases. There's been railroad strikes that have been averted because the federal government has said, you guys will mediate your dispute because we can't afford to shut down the railroad. It's shipping too many of our goods to places that need it, and so we're not going to shut down the railroad. So you guys have a cooling off period, and we're going to appoint a mediator, and away they go, right? Both sides. So that can happen, right? If the government thinks that this is the dispute is large enough and it could disrupt our economy, they'll mandate mediation. Oops. Lack of judicial involvement, yep. No judges involved, anything like that. Conduct of mediators not subject to judicial review, okay? But that's because the parties can say, no, we don't agree, right? Nothing's happened here. The parties themselves, have no obligation to agree with anything that the mediator comes up with. We're seeing some flexibility, some mediation / arbitration. Again, this is new to me. I think this was kind of new to this textbook even, so it's not something that I am really that familiar with or know of any cases, that have happened where it's been both mediation and arbitration, where you agree on, a set of items, but then you arbitrate the few remaining items that are there. But again, the law encourages parties to be creative, and that just gets back to settlement, right? Settlement without litigation. That's the key. We don't want to go to court. We want to avoid court if at all possible. And generally, that's very much the case. Both parties. If the parties to a mediation sign an agreement at the end, that agreement is usually legally binding. In that case, yes, right? Okay. If the parties have agreed to it, it is legally binding. The important difference is that the mediator cannot impose a binding solution. Advantages of arbitration over litigation. We already did that one. Am I going backwards? Some other, we talked about the combination, the mediation / arbitration. And again, these two, I told you at the beginning, I'm just not familiar with those happening in the state of Montana. They could happen. I mean, there's nothing wrong with two parties that would get together and instead of mediating or arbitrating, they would have a mock trial. They would hire, 6 or 12 people and say, we're going to present our case in front of you and you guys are going to render a theoretical or hypothetical decision. And after that, then we can kind of take it from there and see what we want to do, right? Or you could have a mini trial. And again, that would be, very similar. You might hire, in that case, a retired judge. And the retired judge is going to make it, going to make not decisions, but going to tell you the law, going to tell you a lot of those things, right? And maybe help you with the facts of the case, so not just the law. Dang, we're kind of right at that time when it'd be nice to start the next chapter, but by the time I get going, it's going to be time to quit anyhow. So we've got basketball. It's online. I don't know if you guys watched it. Anybody watch the wrestling last night? Oh, I got to tell you about it. It was so much fun. We were down, team score 15-10, and kind of one of the middleweight matches was coming up. and these guys were grappling. Their guy was ahead of our guy, I think 14-13. And the announcers were saying, just 4 more points, and then because they were partisan to Great Falls, 4 more points, and it had been a tech fall for their team. And they get grappling again. Our guy ends up on top. Badley, I think his name was. I'm not familiar with him. Pins the other guy. So we get 6 points and go up 16-15, and then we won the last couple matches, and I think ended up winning 22-15 or something like that. So it was a blast. You guys got to start, tune it in on your computer.
We couldn't watch the basketball game last night. It was not on the TV, not on the computer.
What basketball game?
Lights were.
Lights weren't playing last night, just the wrestling.